succeed at the other stage is the reason why you prevent taking irreversible decisions. And my lord, what is the scenario that we are talking here? My lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
To keep speculating about the swearing in of Professor Kindiki.
The issue of swearing in is
also, and he's referred to it 3 times now. This is the 4th time.
My lord, I believe that's the law. They have been saying they want to.
And my lord, whereas you
proceed then.
I was to ask my lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude so that we are all fair. They will have their time to respond, and I will not interfere with it. My lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing while this petition is pending, my lord, that, to borrow the words of Honorable, my friend Muigai, Senior Counsel, would be the greatest absurd. Why is it an absurd? And my lord, why is it an absurd? And my lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those 2 positions, then you do the swearing. My lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My lord, public interest has been defined in very many cases that are before you. And my lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing. Because we actually have a transformative Rugaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gethu Muigai, will be familiar with this. Lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Muigai we understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware it has a legitimate interest in seeing that a crime or corruptions and economic crimes and simply lock them up without status or former status. What orders should we make in the motion before? With regard to interest, as understood, is that public interest means enforcement of the Constitution. Secondly, my lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my Lord, it will be the submission that this reinforces the huge burden that this court must undertake. And, my Lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with the decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, where, if that were to be the case, you would be seeing the Chief Justice swearing on Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a hollow victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our Constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the Constitution was any person who will hold the office of Deputy President and therefore can potentially become President without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political, an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My Lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something much into it. My Lord, the only down that I would like to point myself to, there is the issues of Githunguri versus Attorney General. It is one of the cases that are before you. The facts in Githunguri are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria tells us, that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this. It emphasized the question of justice. And it emphasized the question of justice in the simplest meaning in plain English. You need to ensure everybody has a fair deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason, whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them. It is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleague, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. My Lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
anybody
but my Lord,
who wants
understanding,
to submit on your side,
yes,
we'll
try to do our best.
You have no more than 30 minutes.
Thank you. We'll do our best. My Lord, for purposes of this case, is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarized themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue. On one of the most celebrated court, Justice Brandeis says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state, has been converted into an all organs of government project. With the result, my Lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project contrary to what was clearly spelled out by our laws. And my Lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks that 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the constitutions. It is within your hands, your lordships and your lordships, to ensure that does not become our scenario. My Lord, Macharia, my colleague, emphasized something, but I want to finish by adding something. My Lord, in June 1982, when Kenya was legislated into saying that Kenya is a single-party state and KANU is the only legitimate organ, this was through a long process. Honorable Rengo, Honorable Mwite, Gibson Kamau Kuria have told me the intricacies of the day, what actually. The month of October 2024, we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your Lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My Lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you. How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They will try to divide the time amongst themselves. My Lord.
My Lord, I'm also.
Yes, my Lord, I was saying that we are also interested parties in the application and we would require 15 minutes.
We will reach you. Your time has not come.
Your Lordship, the presiding judge, Your Lordship, Justice Mrima, Your Ladyship, Justice Mugambi, I will be brief. A famous quotation says that while the legislature is the will of the majority, the court must always remain the conscience of society. That is the spirit of the Constitution. That spirit has been reiterated by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of the authorities before this court, and finally, I will go through the political question doctrine, something that has quite excited the other side, and to debunk the myth that the political question doctrine in any way applies in the context of the Constitution 2010. We are dealing here with an application for the preservation of conservatory orders, and insofar as the application in Petition E15 is concerned in terms of prayer D and E, extension of those conservatory orders to cover the entirety of the proceedings pending judgment and determination. My senior colleagues have gone through the essence and the reasons why conservatory orders ought to be granted. Mine is just to buttress this, that I will urge this court to look at the decision in David Ndii and others. That was a 5-judge bench decision led by Professor Justice Joel Ngugi, as he was. And in paragraph 29 of their ruling, that is dated 26th February 2024, and in that decision, quoting a decision from the Supreme Court of Appeal in Nigeria, United Cement Company versus Dangote Industries, the court says that conservatory orders are prophylactic. They are intended to save the substratum of petitions. And as been ably demonstrated by my colleagues before me, we will sit at monumental oddity, the perfect storm in the teacup, when we allow certain processes to happen, including the swearing in of Professor Kithure Kindiki, who argued with me the BBI decision, that if his swearing in should go on, then these petitions will be rendered academic. That certainly should not be the legacy of this court. This court, in the context ably articulated by my learned senior, we have provided in our submissions to buttress what my learned senior whereby says that an additional limb to be examined is public interest. And we have labored in our submissions, Your Lordship, the presiding judge, to itemize 7 items of why the Constitution, as was articulated by my learned senior Ongoya, why the Constitution qualifies as the highest embodiment of public interest. We are here to argue for a conservatory order to issue as a prophylactic device to save the Constitution. That's our constant north. It should not be forgotten. Still on the question of public interest, my good friends representing the first petitioner have in their bundle of authorities 2 cases. The Court of Appeal decision in Matindi versus the Attorney General, 2023 EKLR, the CAS case, famously called. And then we have the Ojo case, Ojo versus Agriculture and Food Authority and 8 others, 2024. I am reliably told that that was argued by my good friend, Professor Tom Ojenda, my senator, Queen's College alumni. And in that case, this is what the court said, in a nutshell, that we need to a nominee from public office so as to protect the Constitution, the integrity of the Constitution. Keep out that nominee. Let them not go into office. That is what we have been arguing. Ojo, Matindi, CS. Oh, I argued. Elisha Ngoya went through certain positions in law as contained in Justice Mrima's decision, Justice Mwongo's decision, your own decision. Those decisions are not idle. They are not mere words in English. They bear legal consequences by the virtue of the doctrine of judicial comity, that when a court declares itself on a position of law, and in the context of these particular petitions, we are dealing with collegiate decisions. Those decisions enjoy protection by virtue of the doctrine of judicial comity. Lord Justice Newberger, in an authority that we have supplied, the case of Willis and Joyce, 2016. This is the 2 2018 appeal cases. We've provided that. Lord Newberger says this, that so far as the High Court is concerned, puisne judges are not technically bound by the decisions of their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there is a powerful reason for not doing so. That creates an honest precisely Mugambi, that the other side making those determinations for you to depart from the same. Elisha Ngoya, full picture of how odd that will be. We have also provided the case from the Supreme Court of the Parliamentary Service Commission versus Martin Nyaga Wambora. Court there examined decision-making and vacation of the same in the context of a collegiate court. The test has been given there by the Supreme Court. And what the Supreme Court says is that if this court might be tempted to reverse what has been made in terms of decision by a collegiate court, then the error has to be substantial. It has to be demonstrated. It does not simply amount to a question of mere allegation. It has to be shown demonstrably to the satisfaction of this court. I want to move quickly to the question of political question doctrine. My good friend, my brother, Mr. Gumbo, has spent a lot of ink, black and white, submitting on this. And he submitted to this court the authority of, to him and those on that side who submit in that line of thinking, we say this, that the political question is an American constitutional emanation. It is a function of separation unique to the American constitutional context. That's number one. In the context of the Republic of Kenya, that morphed to mean justiciability. And in our context, it has yielded to notions such as ripeness, mootness. And this was done by no other than His Eminent Grace, the Lord Justice Mrema, in the case of Anthony Miano and others, was the Attorney General, 2020 EKLR. Thirdly, the political question focuses on limitation by courts, on the court restraining itself from dealing with matters within the responsibility of the political arms of government. Now, in terms of the US context, and I have said that Mr. Gumbo has submitted on this case, and we wish to respond to him. This is what they did not tell you in terms of Baker versus Carr. Baker versus Carr, 1962, lays down 6 factors that can be used in identifying what a political question is. So the political question within the American context is not a general rule of application. It is applicable, yes, but within certain parameters. And the context in which that political doctrine question principle can be used is where, number one, there is lack of a judicially discoverable and manageable standards for resolving the dispute. In other words, the judiciary does not have the wherewithal to deal with that question. Number two, the impossibility of deciding the dispute without being to the detriment of a political policy determination that has been made. Number three, the impossibility of the court undertaking such independent resolution without expressing a lack of respect to government. The unusual need for unquestioning adherence to a political decision already made. Number five, the potential embarrassment and textually demonstrable commitment to the issue of a coordinate political department. Those are the 6 circumstances according to Baker versus Carr. So the question, Your Lordship, Presiding Judge, what will be the usefulness of this doctrine in Kenya? The Constitution of the Republic of Kenya, David D. and others, the Constitution of Kenya has an internal theory. As Elisha Ngoya articulated, and as was articulated in BBI, the Constitution is a transformative Constitution, such that our tenor, our tone in terms of Constitution is radically different from the American. From the text of our Constitution, this is what the Court of Appeal in the BBI decision said at paragraph 139 and at paragraph 144. At paragraph 139, the Court of Appeal said that the Superior Court, being this court, by virtue of Article 22.1, 23.1, and 258.1 of the Constitution, had jurisdiction to complete and incomplete breaches of the Constitution. Your Ladyship, Your Lordships, the substratum in the BBI case was a bill that was stopped in its track before signature. That is important in terms of this context. At paragraph 144, this is what the Court of Appeal says, that when matters involve a threat to breach constitutional rights, justiciability requirements are satisfied and hence the court is allotted. The court is seized with jurisdiction when a breach of the Constitution. Constitutional texts, plain reading. Article 4.1 read with Article 4.2 together with Article 1 provide an interface between law and politics. I repeat, 4.1, 4.2 as read with Article 1 provide an interface between law and politics. The requisite of power ultima, sovereignty in the people, and the requirement by the Constitution that government and governance must be in accordance with the Constitution to establish government, including appointments, otherwise than in conformity with the Constitution, is unlawful. Article 2, sub-article 2, no person may claim or exercise state authority except as provided. And in conclusion, Your Lordships, Your Ladyship, in an old story, and it's probably even true, when the authors of the American Constitution declared after months of work in Philadelphia that they finally reached consensus, a lady by the name Mrs. Powell shouted a question to the revered Benjamin Franklin, an American statesman, who was then 81 years old. And then Franklin, Dr. Franklin, what have you given to us? A monarchy or a republic? And this is what Your Lordship, Your Ladyship, Dr. Franklin answered the lady. A republic, if you can keep it. The judiciary must stand as the unyielding guardian of the Constitution, the pillars of justice and democracy begin to crumble. I submit. Thank you.
Thank you. Bananjeru,
Yes, my lady, my lords.
how are you?
I'm well, my lords.
You have 10 minutes.
My lord, I'll try to do the best within the time allocated.
All right.
My lord, my lady, my lords, permit me to join issues with the earlier submissions made by my learned friends, and permit me, my ladies, my lords, to submit that my submissions will majorly
Issues on the same side. Join issues. We haven't submitted.
What problem do you have with that, Professor Gender?
My lord, join issues means he's on the opposing side, but he's supporting the applications as free as Simply a question of not knowing that we haven't spoken, perhaps. He's running low on sugar.
My Lord, the presiding judge, you made an important point that we are Africans.
I think let Njiru proceed.
And he will have his time to speak the right English when his time comes. My ladies, my lords, my submissions will deal with the aspects of public interest in respect to the reason why the court must sustain the in-government or out-government in whatsoever organ. My lords, in my address, I'll majorly deal with the question of the purported nomination of Professor Kithure Kindiki and whether the lifting of the conservatory orders will culminate into his swearing in and what that means in respect to the provisions of the Constitution. My ladies, my lord, it is clear that a purported process took place in Parliament that culminated into a name being forwarded to Parliament for voting. My ladies, my lords, it is important for us to interrogate the circumstances that led to the forwarding of this name, and whether or not that process is confirmed with the dictates of the Constitution. My ladies, my lords, on the 18th of October, we walked towards what friend Mr. Ongoya submitted on a memorandum by the President. The said memorandum, my ladies, my lords, that the President from the independent and the answer was sufficient enough to afford him the courage to forward the name for voting in Parliament. The question begs and is, did the IBC possess the requisite constitutional capacity to submit or approve the said name for purposes of voting in Parliament? It is important happens that the current president is in admin and has no capacity or ability to execute the function under Article 99 as read together with Article 137 of the Constitution. But ladies, my lords, the Constitution has read together created distinct functions that for the commissioners and the secretariat. And you'll find that, my ladies, my lords, in the decision, consolidated petition number 305, which was between Engineer Mwaura Kamau, Charity Kalukingilu versus EACC. A three-page judge, my ladies, my lords, had that to consider whether the secretariat, in the absence of the commissioners, can take the functions designated and exclusively allocated to the commissioners. My ladies, my lords, at paragraph 347, this is what the court had to say. From the foregoing provisions, it is clear to us beyond that the membership of the Constitutional Commission is between 3 and, in other words, and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said at paragraph 353, I refer the court to have a look at but of the most importance is what the court said relied in the case of petition number 46 of 201. The court relied in a Ugandan case, and this is what the court said.